G'day everyone and welcome to video 4.1.2 for the Legal Studies guy. Our quote today is from Amelia Earhart, famous pilot, first female to I'm sure she circumnavigated the globe or at least crossed the Atlantic, and she said the most effective way to do it is to do it. I know we live in, and this is a theme that's come up in quotes before, we live in a bit of a society these days where there's lots of chatter about what we might do and what we can do and what we should do, but not enough actual doing. So when it comes to your study plans and getting the results you want, the most effective way to do it is to do it, to actually do the work. 4.1.2, we are looking at what is known as the Division of Constitutional Lawmaking, the Division of Constitutional Lawmaking powers of the state and Commonwealth, including exclusive, concurrent, and residual powers. So we'll learn what each of those are. It's a little bit of a new area, I suppose. It's not new to the study design. It was in the old study design, but it is generally something that most students haven't seen before. It's not covered in this sort of language really at year 11. Some teachers might, most don't. And it's only recently been added into the curriculum for junior years humanities. So there's a chance that you've never come across these terms before or these ideas in the division of lawmaking power. So we'll work through it. You may have come across before levels of government, so like local government being your councils, and then the state, and then the federal government. So this is what this is in regards to what can each of those levels do. Our skill for that is we are going to be able to compare the constitutional lawmaking powers of the state and Commonwealth parliaments. So we're going to be able to look at what do the states do, what does the Commonwealth do, and what are the similarities and differences between those through these terms, exclusive, concurrent, and residual. And obviously our essential question is pretty straightforward. What is the division of powers? And we'll jump into that so that we know. Apologise for my croaky voice as well. A bit under the weather at the moment, and I can feel it, or I can hear it being very, very croaky. So, what the division of powers is, and we call it the division of powers shorthand, so you can nice and easily just do DOP. The division of powers is the splitting up. We've got to be really careful not to use the word separating, because separation of powers is a different concept that we have to learn in slides, key knowledge point 4.1.4. So we don't use the word separating. It is the splitting up of lawmaking responsibility between the Commonwealth Parliament and state parliaments, aka what areas does the Commonwealth get to make laws in, and what areas do the states get to make laws in? Because obviously it would not make much sense if they were both making laws in the same area all the time. So this is what the division of powers is. A little bit of a warning around language. These things here, residual, exclusive, and concurrent, we refer to as types of lawmaking power, and then within each of those types are areas of lawmaking power. So an area might be criminal law, or an area might be family law, marriage law, etc. So these are types of lawmaking power, so residual powers, versus areas, which are specific things that laws will be made about. So let's dial it back to the 1890s, 1901, as Australia is about to become a country. And one of the things that the states were really concerned about in becoming one country was that they would lose a lot of their power. They would lose the ability to have control over their own affairs, that the Commonwealth Parliament or the Federal Parliament would just take control of everything, and states would kind of become obsolete. And still to this day, we talk about the differences between Western Australians and Queenslanders and Victorians and that sort of thing. And back then it was really quite a big deal, this idea that someone over on the other side of the country might be making decisions for me in Western Australia. So the state parliaments wanted to really maintain a lot of their own lawmaking power. So one of the main issues with becoming a country was working out exactly what the federal parliament would have responsibility over. And what they did was they made a big list in the Constitution. And anything that they gave to or listed in the Constitution and gave to the federal government, we refer to as a specific power because it is specifically listed in the Constitution. So there are two types of specific power that are listed in the Constitution, and they are exclusive powers. So exclusive powers are in the Constitution. So this is where we're looking here in the middle. And these are areas that the states are not allowed legislate in. So some areas of lawmaking power are given to the Commonwealth and also taken away from the states in 1901. These include things like military. So there's a section of the Constitution that says that no state shall raise its own military, naval force, etc. Okay? So these powers become exclusive to the Commonwealth, it being that the states cannot legislate in them, either due to another section of the Constitution, like the bit that says that the states can't raise their own army. They are listed in Section 52, which we'll look at in a moment. So there's some that are just listed that says Section 52 is these powers can only be used by the Commonwealth effectively, or they're exclusive by their nature. Okay, so there's some areas of lawmaking power that just because of what they are exclusive to the Commonwealth and the states can't use them. An example of this is immigration. So immigration, deciding who can and can't enter the country, who needs what type of passport, or what type of visa, that sort of thing. It's illogical for the states to be able to make laws in that area because the states aren't a country. Immigration is about the movement from country to country of people. Therefore, logically, that is an exclusive power because the states have no ability to legislate on it. There's no logical way they can. The other type of specific powers are called concurrent powers, and concurrent obviously meaning at the same time. That's literally the meaning of the word. And these are things that are in the Constitution but aren't exclusive. And that means that the states and the Commonwealth can both make laws in this area. So this is because when the Commonwealth Parliament started, they were basically like, look, we're going to start with pretty much a blank slate. We'll have a few rules to start with, and then we're going to make them as we go. And these are some areas that we might want to make laws in one day. But until we do, the states' laws can remain intact and the states can change their own laws and stuff like that. So these are called concurrent powers. If the Commonwealth wants, they can legislate in these areas. In most of these areas, they have. But sometimes there can be laws that apply only in each individual state. Outside of that, we have the final type of lawmaking power, which is residual powers. And residual powers is everything else that's not in the Constitution. So this is everything that isn't listed in some way, shape or form. And all of these are therefore left to the states to do what they want with. Now, as you can see from this dot point here, there were certain things that were deliberately left to the states. One of these was criminal law. So what is and isn't a crime? States really wanted to have control over that in their own boundaries, particularly because there's lots of differences across states. So it was a conscious decision not to put what is and isn't a crime, criminal law, into the Constitution so that states could retain that and have their own laws. Other things have developed as areas of law over time. So something like IVF treatment. So for women who want to get pregnant that can't by natural means, this is a new area of law. Laws around IVF treatment and who can and can't have it. It's only been around since IVF's been around, which is less than 30 years. Therefore, not in the Constitution, and the state's responsibility, and each state has different laws around access to IVF. So residual powers are the states, exclusive and concurrent are the federal, and concurrent can also be used by the states. So we could make up a nice little Venn diagram. States are here, federal is here, and there is some crossover between the two of them. And the crossover is concurrent powers, and the states have residual, and the federal government has exclusive powers. The easiest way to remember this, in my opinion, is just literally in the names. Residual comes from the word residue. Residue means what's left over. So if you've ever washed the dishes at home and you let the sink water out at the end, you might have noticed that there gets kind of that scummy layer around the outside. We call that a residue, what's left over. Okay? So literally the states have residual powers, they have leftover powers, the powers that were left out of the Constitution. Concurrent means two things at the same time, therefore states and Commonwealth at the same time, so both can legislate there. And then exclusive powers are the Commonwealth's only, so left to the Commonwealth. We can put this into a flowchart. Basically, if you want to know whether an area of lawmaking power, or what type of lawmaking power an area is, say we're looking at education, so laws around education. The first question we have to ask is, is it in the Constitution? For those of you who know this already, the answer is no. It's not in the Constitution, which therefore means straight away it is a residual power. So that's pretty simple what we would do for education. But say we were asking about marriage. Is it in the Constitution? Yes. Therefore, we know it is a... I'll flick back. Therefore, we know it is a specific power. And then from there, is it exclusive by its nature, by another section, etc.? And in this case, it isn't, which means it is a concurrent power. Okay. Another example might be military, so ability to raise an army, etc. Is that in the Constitution? Yes. So it's a specific power. Is it exclusive? And we know that by or due to another section that says that states cannot raise their own military, it is, which means obviously it is an exclusive power. So you can simply draw this up in your book at home, a simple flowchart for how you work out what type of lawmaking power each area is. Is it in the Constitution? Yes or no? If it is it exclusive? Yes. If not, concurrent. If it isn't in the Constitution at all, it's just a residual power. Section 51 of the Commonwealth Constitution is where we find the list of all the powers. And this is important because of this skill. Compare the constitutional lawmaking powers of the state and Commonwealth Parliament using examples. AKA, we need to know some areas. We need to know examples of concurrent powers, examples of exclusive powers, examples of residual powers. So Section 51 of the Commonwealth Constitution says, the Parliament shall, subject to this Constitution, have power to make laws for the peace, order and good government of the Commonwealth with respect to. And then we go into a big list. So this, and up until here are all the things that the Commonwealth has been given lawmaking power over. And nearly all of these are concurrent powers. So as we can see, if you're good at Roman numerals, that is 39. So there are 39 things that the Commonwealth is given lawmaking power over. And again, as I said, most of these concurrent powers. So we know examples to use. A concurrent power is laws around marriage. Hence why the federal government had a law that said marriage must be between a man and a woman. And it was up to the federal government to change it to say a marriage is between two people with the recent same-sex marriage debate. another example of a concurrent power is divorce, parental rights, and custody and guardianship. Okay, so most states have their own family law courts and only their own family law system, but it is an area of concurrent power. Another area of concurrent power is, we have a look through, there we go, that's the one I was looking for, sorry, taxation. So most taxes that we know of, like income tax that comes out of your pay, is a federal tax. GST that you pay on all your goods and services, a federal tax. But there are some examples of state taxes, such as payroll tax, which businesses pay, and added tax on the wages they pay, and this goes to the state government. Stamp duty, so if you buy a house, you pay a special tax called stamp duty, goes to the government. So there's three areas of concurrent power that you can use as examples: marriage, other areas of family law like divorce, custody and guardianship of infants, and taxation. Okay? Then, as we said, Section 52 has exclusive powers. Okay? And these are ones that maybe you're not going to want to use, but these are the listed powers in Section 52 for exclusive powers. The seat of government of the Commonwealth is the Parliament can only make laws around where the seat of government of the Parliament shall be. Makes sense. Or seat of government of the Commonwealth, sorry. Any matters related to the public service in any of these areas. Okay, so that's why we have, Foreign Affairs Ministry, etc., etc. And any other matters declared by this Constitution to be within the exclusive power of the Commonwealth, which means any other things that are made exclusive by certain sections. So if we wanted to make a list of three really good exclusive powers to use in answers, you would say the military, because there's a section of the Constitution that says that no state shall raise its own military. You would say currency, because there is a section of the Constitution that says that no state shall have its own currency and its own legal tender. And then one that is made exclusive by its nature would be external affairs, aka international relations. And this is one that comes up in dot point 4.1.7 about the external affairs power and the scope of that for a government to meddle in domestic affairs. So there's three exclusive powers. I've given you three, 1, 2, 3 concurrent powers to know, and some great residual powers, those things that are not on this list at all to remember: education, health, and criminal law. Okay, so nice, easy ones to remember as those examples. So what could that question look like? You're probably more likely to get asked specifically to explain concurrent powers using examples or explain residual powers using examples, but you potentially get something like this for 4 marks. Using examples, compare the lawmaking powers of the state and Commonwealth Parliament. For those of you who are new to this or haven't come across this before, it's well established in legal studies that compare means that you need both similarities and differences. So you can't just do things that are the same. If you're asked to compare, you must say what's the same and what's different. So therefore, for this answer, pretty straightforward. The similarity between the Commonwealth Parliament and the state parliaments is their ability to legislate in concurrent areas, so areas of concurrent power. These areas, my example, like marriage, are in the Constitution but are not made exclusive, meaning both the states and Commonwealth can have their own laws about marriage. Pretty straightforward. Outside of concurrent powers, however, the lawmaking responsibilities of the Commonwealth and states differ. So using that clear language, differences. Anything not listed in the Constitution, such as criminal law, so using an example, is referred to as a residual power, and states have the ability to make their own decisions on what does and does not constitute a crime. Further, the Commonwealth has exclusive lawmaking power over some areas as well. These areas are listed in the Constitution, such as naturalisation, so that's who gets to be a citizen, and by their nature, states cannot make law in this area as it is logically a national responsibility. So just pointing out, hey, some things are the same, concurrent powers, but some things are different, and they are residual and exclusive powers. To finish off, I have links again, and I'm linking you straight to the Parliamentary Education Office. Again, they have a great fact sheet on the division of powers that I recommend you have a read to further your understanding a little bit more. And the other one is, by all means, just literally Google Australian Constitution. This is a link that takes you to a PDF of the Australian Constitution. Sorry, a web page, and you can click on the different sections. But you can literally just Google Australian Constitution, find a PDF copy, and have a little look through. There's some interesting sections and some funny stuff in there. And there's some interesting things in Section 52, like that the Commonwealth has the power to make laws over lighthouses, lightships, beacons, and buoys. So, yeah, the Commonwealth Parliament can control all the buoys if they want. Hopefully, at the end of that, again, something that you probably haven't heard of before. It's not exactly common knowledge. If you ask the random person down the street what the division of powers is, they'd probably look at you like you've got three heads. Same deal if you ask your parents at home, perhaps there's a chance that they won't have any idea what you're on about. It's not exactly common knowledge, but it is just the idea of what does the state parliament get to do versus what does the federal parliament get to do. So hopefully you can answer that essential question of what is the division of powers. Hopefully I'll see you tuned in again for video 4.1.3. It's going to be a really short one as we look at what happens if the states and the Commonwealth have laws that contradict each other. This has been a Legal Studies Guy. Make sure you subscribe. Make sure you sign up to the website and give us a like on Facebook as well to keep up to date with all the happenings.